Imagine this. It's your first week working as an immigration paralegal. You are organized, ready, and excited to prove yourself. Then the attorney walks in and says, hey, we need to file with the EOIR and respond to USCIS by Friday. And suddenly your mind goes blank. Why two filings in two separate agencies? For context, EOIR is the immigration court. USCIS is the agency that handles applications like green cards or work permits. Two completely different processes on the same case. That kind of confusion isn't because you are unprepared. It's because immigration law isn't like most areas of law. It's made up of multiple agencies, each with its own rules, systems, and priorities. And if you are a paralegal, your job isn't just to fill out forms. It's to guide a case through all of that and to know where it's going before things start to move. So in this video, I'm going to give you a clear, simple map of the US immigration system. Not just a list of acronyms, but a working overview of who handles what and how it all fits together in practice. By the end, when someone says, this is an EOIR issue or we are just in status through USCIS, you will know exactly what that means and what steps to take. Now let's take a closer look at the key agencies that actually run the US immigration system. These are the institutions you will interact with as a paralegal depending on the type of case you are helping prepare. Some of these agencies handle benefits applications, some handle enforcement and removal, and others come into play only in very specific situations like appeals or overseas processing. But once you understand the basic structure, it becomes much easier to figure out where a case is going and what needs to be done. First, let's take a look at the Department of Homeland Security, or DHS. DHS oversees three of the most central agencies in immigration law: USCIS, CBP, and ICE. USCIS, or US Citizenship and Immigration Services, handles most immigration benefits when someone is applying inside the United States. That includes green cards, work permits, naturalization, humanitarian protections, and family-based petitions. This is an administrative agency, so no courtrooms, just forms and officer review. There's CBP, or Customs and Border Protection, which is responsible for what happens at the border and at ports of entry, like airports and land crossings. This includes inspections, admissions, and expedited removals in certain cases. And then there's ICE, Immigration and Customs Enforcement, which is the enforcement arm of the government. They issue notices to appear, detain individuals, and prosecute people in court. In removal defense cases, ICE acts like the government's lawyer. And if you've seen headlines lately, you know their detention operations are happening all over the US. Now let's talk about the Department of Justice, or DOJ. Once someone is placed in removal proceedings, the Department of Justice takes over, specifically through the Executive Office of Immigration Review, or EOIR. EOIR runs the immigration courts. Immigration judges conduct hearings and issue rulings in removal defense cases, like asylum, cancellation of removal, or motions to reopen. If a case is denied in immigration court, the next step is usually the Board of Immigration Appeals, or BIA. The BIA reviews decisions by immigration judges. Unlike court hearings, BIA reviews are done in writing, based on the record and the legal arguments submitted. 3. Department of State, or DOS. The Department of State comes into play when someone is outside of the United States and needs to apply for a visa. This is called consular processing, and it's handled through US embassies and consulates around the world. These visa interviews, reviews, and decisions fall under the authority of the DOS, not DHS. And once the case is overseas, paralegals are often responsible for preparing the consular packet, double-checking eligibility, and confirming documentation through systems like CEAC. 4. Department of Labor, or DOL. Another agency that occasionally enters the picture is the Department of Labor. This applies mostly in employment-based cases that require a labor certification, such as certain green card categories. We won't go deep into that in this video, but just know that when you hear about perm or prevailing wage requests, you're likely dealing with the DOL. 5. The Federal Judiciary. And finally, we have the judicial branch, which includes both the federal circuit courts and the Supreme Court of the United States. When someone loses at the BIA, they may be able to file a petition for review with a federal court of appeals. This isn't a new trial. It's a legal review of whether the agency acted within the law. And yes, some cases can eventually reach the Supreme Court. In fact, the Supreme Court has issued several major decisions in recent years that have shaped asylum eligibility, detention limits, and even the way NTAs are issued. So while it may feel far removed, it is a critical part of the system, and understanding it helps you track how immigration law evolves. So those are the core players. Each one plays a different role, but they all intersect depending on the kind of case, where the person is, and what relief they're pursuing. And the structure of those agencies starts to make even more sense when you look at how immigration cases are divided. At their core, almost every case falls into one of two tracks: affirmative or defensive. Let's break that down. An affirmative case is when someone applies for an immigration benefit on their own, before the government takes any enforcement action. These are typically handled by USCIS or, in some cases, the Department of State. Think of someone applying for a marriage-based green card or naturalization. The applicant is the one initiating the process. In these cases, there's no courtroom, no judge. It's mostly forms, supporting documents, maybe an interview, and then a decision by an officer. And as a paralegal, you're going to spend a lot of time in this space, preparing applications, assembling evidence, tracking receipts, following up on RFEs. Now, a defensive case is a completely different experience. This is when someone is already in removal proceedings, meaning the government is trying to deport them, and they're defending themselves in immigration courts. In these cases, the person may still be eligible for relief, like asylum, cancellation of removal, or adjustment of status. But now the process is adversarial. There's a government attorney on the other side, and the decision is made by an immigration judge. These are handled under the Department of Justice, specifically EOIR. And as a paralegal, your role here becomes more litigation focused. You might be preparing declarations, organizing exhibits for hearings, filing motions, or helping the attorney prepare for trial. Understanding whether a case is affirmative or defensive doesn't just tell you who handles it. It tells you everything from the timeline to the kind of evidence needed to the way your legal team needs to prepare. Now that we've talked about the two main types of cases, affirmative and defensive, let's take that understanding one step further. Because here's the truth. Immigration cases don't always stay in one lane. In fact, many real-world cases involve more than one agency. And if you are a paralegal working on a case like that, it is your job to understand how those parts connect. And here's where even experienced paralegals can get tripped up unless you know what to expect. So let me give you a couple of examples. Let's say your client is in removal proceedings, but then he marries a US citizen. Now, you're not just dealing with the Department of Justice through EOIR. You will also need to file an I-130 marriage petition with USCIS, which is part of DHS. And if that I-130 is approved, you might request that the court terminate proceedings so the client can adjust status through USCIS. Or, in some cases, you might pursue adjustment directly with the court. So one case, but now you're coordinating between two agencies, each with different systems and timelines. Here's another situation. Someone applies for asylum affirmatively with USCIS, but they get referred to court. Now, the same asylum continues, but under a different agency in a courtroom with different procedural rules. USCIS started the process, but EOIR will finish it. And as the paralegal, you will probably reuse the same declaration and much of the same evidence, but you will also need to gather new materials and reformat everything for a courtroom setting. And here's the tricky part. USCIS and EOIR don't just follow different workflows. EOIR operates under its own system, with forms and formatting that are entirely separate from what USCIS uses. So even when the facts stay the same, the way you file, frame, and submit the case can be completely different. All of this is why it's so important not to think of immigration law as one agency, one form, or one process. In many cases, immigration law works more like a relay race than a straight line. A case can move from DHS to DOJ or vice versa, but not every case will. Some stay entirely within one agency like USCIS or EOIR. If you can track cases across agencies without dropping a thread, that's when you stop being just a form filler and start becoming indispensable. Now let's talk about something a little more personal. Something I don't think paralegals hear enough, especially when they're just starting out. What do attorneys actually need from a great paralegal? I've worked in this field for years, trained teams, reviewed resumes, supervised real people in real firms. And I'll tell you this, the most valuable paralegals aren't the ones who know everything. They're the ones who understand what really matters in practice. If there's one trait that sets great paralegals apart, it's how they handle deadlines. I've seen it all. Jobs lost because of a filing was late, RFEs ignored, or motions rejected. One missed signature or wrong form version can cost clients months and sometimes their entire case. As a paralegal, you're not just organizing papers, you are managing time-sensitive legal processes. And in immigration, almost every benefit or defense comes with a deadline. Another thing attorneys really rely on paralegals for? Details. Every case has 100 of them. Miss an A number, mistype a date, forget to update an address. These aren't just small errors. They can derail a filing, trigger red flags, or slow a case by months. You might think it's just a typo, but immigration officers and judges are trained to spot inconsistencies, and those little mistakes can cost time, credibility, or even the case itself. Here's something a lot of new paralegals don't realize right away. You are the client's main point of contact. Clients won't always speak with the attorney, but they will always speak with you. In fact, in most law firms, clients interact with paralegals far more often than with the lawyer. They will share their stories, fears, and questions, and how you respond reflects the entire firm. Now, that doesn't mean the paralegal gives legal advice, but it does mean you are the bridge between the attorney and the client. And how you manage that role really matters. I've seen this time and again. A good paralegal doesn't just make the lawyer look good, they make the client feel seen and supported. And that's something that people never forget. You don't need to know everything, but if you ask questions, double check procedures, and actually dig into how things work, your value skyrockets. I've seen it firsthand, not just from others, but in my own experience. I've caught issues just by reading a denial letter carefully. I've spent time with the policy manual, and found better ways to present a case. And you know what? That kind of attention to detail earned me raises, and more importantly, the trust of the attorneys I worked with. That kind of trust is invaluable. So if you're thinking, hey, that's a lot of responsibility, yeah, you are absolutely right. But the good news, every one of these skills is learnable. And that's exactly what we're doing in this channel. 2025 is already proving to be a turning point. We're seeing a wave of policy changes that directly affect how immigration law is practiced and how paralegals support both clients and attorneys. 1. The end of prosecutorial discretion. One major change is the rollback of prosecutorial discretion, the policy that previously allowed DHS to pause or close certain removal cases based on humanitarian factors or family ties. That discretion has been officially rescinded, and in its place, we're seeing a significant push to reactivate cases that were previously administratively closed. This is leading to a sharp increase in motions to recalendar, bringing thousands of cases back onto immigration court dockets. For paralegals, this means more hearings prep, FOIA reviews, and updated filings for cases that may have been inactive for years. 2. Termination of Temporary Protected Status, or TPS. Several major TPS designations have ended in 2025, including those for Venezuela, Haiti, and Nicaragua. The Supreme Court upheld the terminations, meaning hundreds of thousands of individuals could now face removal. Many of these cases involve long-term residents with deep family and community ties. As a paralegal, your role might involve reviewing eligibility for other forms of relief, helping draft motions to reopen, or updating client records in case of enforcement activity. 3. Faster enforcement, shorter timelines. We're also seeing more frequent use of expedited removal and changes to ICE enforcement priorities. People with prior orders or unresolved filings may be contacted more quickly and in some cases detained. Without the buffer that discretion once provided, timelines are tighter and errors carry greater consequences. This makes attention to detail and proactive tracking more critical than ever. What this means for paralegals. For you, these changes aren't just theoretical. They impact your day-to-day work. You may find yourself reactivating old files, tracking changing client eligibility, or preparing motions with faster turnaround times. More than ever, success as a paralegal depends on your ability to stay organized, stay informed, and support your team through fast-moving legal environments. All right, if you've made it this far, I want to say thank you. I really hope this video gave you a better understanding of the US immigration system and how paralegals like you fit into it. We've talked about how the system is structured, how different agencies interact, how cases move, and what makes paralegals truly valuable in this environment. But hey, there is so much more to explore, and I'll be covering many other topics in future videos. If this one helped you in any way, I would love to hear your thoughts. What part of immigration law do you want me to cover next? I want to know also what's been the hardest part to learn so far. Drop a comment below. I read all of them, and of course, if you want to keep learning and growing with me, feel free to like this video and subscribe to the channel. Thanks again for watching. Keep your steps steady and your purpose clear. I'll see you in the next one.